government is not arbitrary. And I would like us to unpack that using the model of the rule of law that has been designed by the World Justice Forum. What is the rule of law? So we say it's a situation where no one is above the law, where there's no impunity. If you do something wrong, you will account for it. If you do something right, you will be rewarded for it, where everyone operates according to the rules. In fact, one of my students recently said, her understanding of the rule of law is when the rules rule. How do we make sure that the rules rule and it's not the people who rule? Because somehow these rules have to be interpreted by the people. The World Justice Forum says there are 4 conditions that should exist for the rule of law to prevail. These are the 4 conditions. There has to be accountability. People have to be answerable for their actions. And if they've done something wrong, they have to take responsibility, and when a remedy needs to be implemented, a remedy must be implemented. So that was the first thing. There has to be accountability. And this is not just state accountability. Government must be accountable. But everyone has to be accountable for their actions. If I take that iPad that's not mine, somebody has to ask me, why did you take it? And I have to account for my actions. And if I harmed somebody by taking that iPad, I have to make amends. So that's part of accountability. It's accountability by those who exercise state power, it's accountability by business, accountability by ordinary citizens, accountability between countries, and things like that. The rule of law also requires that laws should be just. And that's one thing that we often forget about the rule of law. We think it just has to be the law. Not many people here were grown-ups under apartheid like me. But even if you were not there, the one thing you may have been told is that there was law under apartheid. And if there was one thing that operated with precision, it was the law. What's the difference between law and apartheid and law in a rule of law society? Under apartheid, and in many societies where the laws are not just, you get ruled by law and not the rule of law. Ruled by law, the laws should be just, and at the core of those laws should be the protection of human rights. And not just the human rights of some people, the protection of everyone. And you will know that in the South African Constitution, the rule of law is one of the founding principles, is one of the foundational principles of the democracy. And as articulated in Section 1 of the Constitution, and the Bill of Rights is the anchor of the kind of society that is the rule of law society, because it has to be a just society. Otherwise, there is no rule of law. If laws are not just, you do know that nobody's going to obey them. Look at what's happening with e-tolls. How much money is going to be spent in trying to compel people to comply with e-tolls? In a rule of law society, there'll be police, there'll be policing, there'll be courts, but the majority of people should comply with the law because they feel comfortable with these laws. They feel that these laws are creating a society where all of us thrive, where all of us are treated fair. When laws are just, people consider it just to disobey the law. And that's what happened in apartheid. We considered many of the laws to be unjust, and we thought that justice dictated that we disobey some of those laws. Sadly, the disobedience of law tendencies creep beyond the utility of those tendencies. Now we get people who don't want to pay their electricity maybe let's not go there. But that's why you need the rule of law, because once people go to what the Chief Justice refers to as self-help, then it becomes every person for themselves, survival of the fittest, and chaos, basically, chaos. The third requirement in a rule of law environment is open government. And open government is basically about laws have to be made or created with the participation of the people. It's very difficult though in modern societies, isn't it? 57 million people and you're creating laws. It's not the same thing as traditional societies or the societies where Aristotle came up with these ideas where, they were small societies. But that said, it's still a requirement that when laws are made, people's views are canvassed, and it's not just malicious compliance. The Constitutional Court has said there has to be meaningful engagement. In the blue light case, there has to be meaningful engagement. And again, the state won the case on e-tolls. It won the case on the principle of separation of powers because the courts chose not to get involved. But on the rule of law principle, you ask yourself, would we be having this mess if there had been meaningful engagement? But if there had also been consideration of human rights, because just laws are not laws that treat me and my helper the same. If you increase VAT, for example, by 1%, it would mean if I was going to buy a shoe for 1,000 rand, for me, it's now an extra 10 rand. But to the helper, 10 rand is taxi money for the day. And therefore, if you treat people the same, it's not justice. It's law, but it's not justice. And Justice Ismail Mohammed, who was one of the early Chief Justices under, he was the president of the High Court during the early days of democracy, was very concerned about us taking a journey post-apartheid to close the gap between law and justice. Right. The last thing that you need in the rule of, as part of the rule of law is accessible and impartial dispute resolution. And this is one of the most difficult things, accessible and impartial dispute resolution. How many of you feel that traditional courts should be thrown away? Put up your hand. If you think traditional courts must be thrown away, the Bantu-style courts, as some activists are calling them. You do think so, sir? Thank you. Well, let's honest. When I was a young researcher at Wits in my early 20s, I too thought traditional courts should go. I thought customary law should go. I thought everything to do with tradition should go. You know why? Partly because I was raised as a Seventh-day Adventist. And my church told me that everything African was primitive. That even wearing traditional clothes was primitive. But I look better. That's why I wear pearls, because my church told me not to wear beads. That was a joke. But then I worked with the rural women's movement doing research on customary law, particularly focusing on succession and polygamy, things that we thought should go. I will never forget being at a place called Wangema and having a conversation with women, a round table with women. A huge number of women. There must have been more than 100 women. In the rural area, 100 people in one place is a big number because people have to travel long distances. And the women there said they don't want to take their rape cases to court. They prefer to take their rape case to a traditional court. Me, being a feminist who thought I knew everything, I was horrified. How on earth would they want to go to these male chauvinistic courts where women are not represented? But you see, what we think women are not represented, but we don't think black people are not represented. Because the courts that we're saying to these women must go to are courts that Justice Edwin Cameron says in his book, Justice. Are courts that are based on what was happening in 16th century Rome, transplanted here and called the common law. And there's nothing common about the common law to the average South African. There's really nothing common about the common law. When you go to court, it's the first time that you get all of those Roman concepts being thrown at you, and you have no idea. If you have to talk about property, for example, the average person doesn't know that when property, when they haven't laid a claim, a title to it, and then somebody has a right to consider it to be res nullis. Many people, for example, create intellectual property, like the lady who created chakalaka. Does anybody know what chakalaka is? Yeah. You know that who sells it. And to know that they pay nobody intellectual property, they pay royalties to no one. Because the grandmother, unlike the grandmother who created Omar Ras, who understood common law, because that was from the home country, the grandmother who created the chakalaka didn't know about intellectual property. And then some lady who thought, this was a good idea. I went for Koo. Can we make this? They also just took it to Koo. And they never thought that, at the very least, maybe you could pay royalties to Sowetans, because it was weddings and funerals in Soweto where they created chakalaka, and maybe you could pay a royalty to the group like they're doing now with the Koi and San people when it comes to rooibos and hoodie. They then distribute the royalties to family. But just to cut this long story short, accessible is not just physically accessible. Dala Omar used to say that it's important that courts and all structures that are given to people to resolve disputes are structures where people have a right to understand and the right to be understood. And many courts don't understand people. And many people don't understand courts. Regardless of race, regardless of culture, regardless of money, majority of people don't understand courts. And they don't get understood. We get lawyers, like many of the lawyers in this room, to try and make sense of it. And I will never forget just the last story about the right to understand and the right to be understood. When I was still in France and working in Carlsdale, one lady came and her property had been taken away. She was a widow, had been taken away by the husband's children and the ex-wife of the husband. But what struck me and still stays with me today was that she had no clue who did what. She just said, I was called to the Benoni court. There was a white woman at the end of the table there. They said something at the end of the day. They told me that I must leave the house and that the taxes are going to go to the church. She had no clue what was the basis of this decision. Why am I telling you this long story? Is that the rule of law requires that people understand the laws and they opt in. If most of the people think these laws are fair, that these laws are about the golden rule, that I would also want to be treated the way I want to treat the next person, the majority of people are going to obey the laws. But it's not really our fault. Our fault as lawyers at this stage is to try and help to make sure that people do understand these laws. And I'm going to talk about